the audience. Welcome for this match of the quarter-finals of the Inter-University Law Debate Tournament 2024, organized by the Corax Foundation. We have two teams who qualified from the 8th finals, so today they are competing to get a chance to get to the semi-finals. So I give the floor to my colleague, Ms. Urbanova, who will be hosting the match.
Thank you very much, and good day, everyone. Welcome to the Prince Sultan University debate team and Sofia University debate team. Congratulations on qualifying for the quarterfinals match. This round, as you know, is on the general theme of disinformation and law. This topic is done and presented in competition in collaboration with the Jean Monnet project, helmed by Dr. Garrido Munoz and Dr. Kostikiewicz, who have also proposed a debate statement that you have received 7 days in advance. As always, we'll know which side of the debate statement will be represented by which team after the introductions. But for now, just a reminder of the topic. It is that big tech companies should be the only ones responsible for verifying the accuracy of the content placed on their platforms, and thus be held liable for criminal or civil law point of view. And before I give the floor to the students and to their mentors that are present with us on the call, I would just like to thank also the 3 judges that will be reviewing this debate within the next 2 business days, and just wish best of luck to the 2 teams. So starting with the Prince Sultan University team, Ms. Hashim, the floor is yours.
Hello, my name is Lina Hashem. I'm a second-year student at Prince Sultan University, and I'm very excited for today's debate.
Thank you and welcome. From the Sofia University team, Ms. Makuchian.
Hi, I'm Teresa. I'm first year of Sofia University.
Thank you and welcome. From Prince Sultan University, Mr. Hashim Ashram.
Hello everyone, my name is Hashim Ashram. I am a first year law student in Prince Sultan University.
Thank you and welcome. From Sofia University, Ms. Angelova.
Hello everyone, my name is Maya. I'm in my second year of law school, and I'm looking forward to our debate.
Thank you and welcome. From Prince Sultan University, Ms. Sahab.
Hi, my name is Judy Sahab. I'm in my 3rd year of university, and I just want to congratulate the team for making it this far. Both sides, really, we've done great work.
Thank you, Ms. Sahab, and welcome. Also, I would like to give a shout out to the mentors of the 2 teams. If I am not mistaken, 3 of which are present with us on the call. Mr. Kychikov and Ms. Donskaya for the Sofia University team, and Mr. Mograbia for the Prince Sultan University team. Perhaps starting with Ms. Donskaya, if there's anything you want to wish to share with the students.
Hi everyone, I can just say that I'm very excited for the debate, and I'm just wishing luck to both teams. I'm sure you will do great.
Thank you, Ms. Donskaya. Mr. Kychikov, go first.
Hello everyone, I hope you can hear me. So I wish luck to both the teams, and I hope that they show their best.
Thank you. And now also floor to the mentor of Prince Sultan University, Professor Mukrabia.
Yes, I would like to echo what Judy said, that I'm proud of both teams for getting this far, and very excited for the debate today. Hopefully they will both do amazing. A lot of preparation has been put into it, and I'm very proud of both of them. And good luck to both teams.
Thank you. And indeed, biggest congratulations to the 2 teams. And in a short while, you will see the screen for the allocation of positions. If I can just get a confirmation that you can see it.
Yes.
Thank you. As always, there are 4 possibilities for the wheel to choose from, 2 for each team. So for today's debate, it will be the Sofia University debate team that will argue in favor of the motion, and thus defending the statement that big tech companies should be the only ones responsible for verifying the accuracy of the content placed on their platforms, and thus be held liable from criminal or civil law point of view. And it will be the team from Princeton University that will argue against this motion. You will now have 5 minutes to finalize your preparations. Feel free to close your cameras, and afterwards, Sofia University will start with the opening statement. Best of luck.
Microphone.
Oh, thank you very much. I was saying thank you, everyone. The time for your final preparation is now over. As always, we'll be starting with the opening statements in the favor position. Thus, the team of Sofia University, you have 4 minutes for your opening statement.
I would first like to ask if I'm audible and visible.
You are.
Thank you. Good afternoon to the fellow judges and to my colleagues from Prince Sultan University. On behalf of myself and my teammate Teresa, we're very pleased to discuss the need for full liability from the big tech companies in connection to verifying the published content. To begin with, according to Financial Times, the term big tech companies shall be understood as the entirety of the largest IT companies in the world, namely the Big Five: Alphabet, Amazon, Apple, Meta, and Microsoft. All of the said are stated in the United States, thus its national legislation could be taken into account as relevant. As established by the US Supreme Court in the case of Stratton Oakmont versus Prodigy Services Co., it is the company that is considered to be the publisher and the author of the published content when they exercise editorial control over it. And clearly, the biggest tech companies like Amazon or Meta do exercise such control. This can be seen from the basic terms and conditions everyone agrees on with their registration. Consequently, it is the big tech's responsibility to regulate and be held liable for any violations caused by the content they provide us with. Dear judges, the opposition may rely on the well-known Section 230 of the Communications Decency Act. This is part of the US legislation that provides for a wider freedom and less liability of the platforms. However, we would like to point your attention to a recent case of the US Supreme Court that overruled this law. In the case of Renault versus American Civil Liberties Union, the US Supreme Court proclaimed this provision as unconstitutional. Section 230 has also faced a lot of criticism in the past by highly qualified publicists, such as the Harvard professor Shoshana Zuboff, who supports the notion that companies are the ones accountable for misinformation shared on their platforms. Today, we argue that big tech companies should be the only ones responsible for verifying the accuracy of the content placed on their platforms and be held liable from a criminal and civil law point of view. In order to support our position, we would like to provide you with additional 3 arguments. Firstly, only big tech companies have the financial and technical resources to verify it effectively. The content. Secondly, the regulation will be more effective when it comes from one source, the companies themselves. Lastly, by holding the companies liable, the security of the users is better protected. To begin with, big tech companies have the financial and technical resources to verify the content effectively. This has been reaffirmed by the European Union in its regulation on tackling terrorist content online by June 2022. The Act elaborates on the nature of the companies and establishes them as fully liable for any terrorist-like content published. Moreover, in case of non-compliance, member states are obligated to sanction the platforms. Evidently, the tendency is to provide for a higher responsibility for the companies. This is reasonable, since they're the only entity that would have the ability to exercise effective control over their own content. This leads us to our second point regarding the efficacy of their control that will be elaborated on by my teammate Teresa. Thank you for your kind attention.
Thank you. Thank you for your opening statement. We'll now proceed for the opening statement in the against position. Prince Sultan University debate team, you have 4 minutes.
First, may I confirm that I am audible and visible?
You are.
Thank you so much. Good evening, esteemed organizers, honorable judges, and the respective proposition team. These big tech platforms are the center of our society. These groups of internet-based applications that have emerged from Web 2 that allow for the creation and sharing of user-generated content. These companies have fundamentally shaped our modern society. They foster and allow for exchange, discourse, and progress. So, should these big tech companies be responsible for the content generated by their users? Of course not. And advocating for holding these companies solely responsible risks bad behavior such as excessive surveillance that can hinder social development. Not to mention completely going against the principles of the Section 230 of the Communications Decency Act, and also poses significant threats to freedom of expression. Now, US jurisdiction heavily applies in today's debate, since a majority of big tech companies are based in the US, such as Google, Facebook, Instagram, and X, formerly known as Twitter. In Section 230 of the Communications Decency Act, it was created with the primary goal of allowing innovation and freedom of speech on the internet, while shielding companies from the burdensome effects of liability when it comes to user-generated content, requiring these companies to undertake the monstrous task of content verification would go directly against the essence of this section, hindering innovation, stifling vibrant exchange of ideas that categorizes this online sphere. In the case of Zirin versus Online American, also known as AOL, Kenneth Zirin sued AOL for failing to remove defamatory posts about him on the platform. However, the court ruled that AOL was immune from liability under Section 230. This radicalized how this section is applied to online platforms. This case set a precedent that these tech companies are simply acting as vessels for user-generated content. They are not held liable, they are simply platforms. In 2015, among numerous cases that have occurred since then, Gonzalez versus Google, where the plaintiffs of a family of the victim of Paris attacks sued Google, YouTube, Facebook, and X for allegedly failing to moderate content that contributed to the radicalization of these attackers. However, the case was dismissed, as were many before. The dismissal of these cases, both in 1997 and 2015, only further shows the exemption that these big tech companies have from the responsibility of user-generated content. Obligating big tech companies to verify the content accuracy would infringe upon the fundamental right of freedom of expression. It would essentially force these companies to act as arbitrators of truth, determining what is permissible and what is not. This would lead to over-censorship, suppression of diverse viewpoints, and stifling free speech, all while undermining what really these platforms exist for. Freedom of expression is a sacrosanct principle, supported by the International Covenant on Civil Rights and Political Rights, and also by the First Amendment of the United States of America. So in conclusion, while we acknowledge the importance of combating misinformation and upholding journalistic integrity, we firmly believe that these big tech companies should not be held solely responsible. Instead, we must seek a collaborative approach where multiple stakeholders across the spectrum safeguard the principles of innovation and freedom of expression, since it is the bedrock of our digital age, while still protecting the masses from misinformation. Thank you for listening.
Thank you very much. This marks the end of the opening statements. We'll now proceed to the rebuttals. Starting with the first rebuttal in the favor position, team of Sofia University, you have 2 minutes.
Am I audible and visible?
You are.
Turning to our second argument, namely, the regulation of content is more effective when it comes from the one source. In the case at hand, the companies themselves. Nowadays, the big tech companies have expanded their ability to exercise control to technological advancement, such as the algorithm that deal faster and easier with any prohibited content. On the contrary, when the power of control is spread to other entities, such as the state, the process became more bureaucratic and less efficient. Furthermore, what our argument is that the state still be able to seek responsibility from the company, but post factum and only in a case of violation. This position was supported by legal scholars in the field, such as Daniel Kintrom and Benjamin Witness in their article 2016 Law Review. In addition, we would like to note that big tech companies are already creating regulatory bodies that verify the accuracy of content. To be precise, Facebook has established an independent oversight board which deals with moderation and thus completes the task of verification. Furthermore, let me point your attention to the case of InfoWars versus YouTube before the District Court of Texas. The court established that it is an obligation of YouTube to ensure a safe and respectful environment on the platform, since it was the only entity able to achieve this goal. Consequently, the full responsibility was left only to the company, which will be liable later if it didn't act fast and remove all of the content with misinformation. Thank you.
Thank you very much. We'll now hear the first rebuttal in the against position. Prince Sultan University team, you have 2 minutes.
Thank you. With respect to the opposition's points, they first pointed towards in the opening speech the fact that in the Reynolds versus American Civil Unions case, Article 230 of the Communications Decency Act was debunked and shut down by the Supreme Court. However, Section 230 of the Communications Decency Act was not the one that was shut down, but rather on other parts of the act that were pertaining to the limitation of freedom of expression. And so we respectfully submit that since Section 230 was not broken down, but rather other articles of the Decency Act, Section 230 still stands. And now going back to Section 230, it says that according to this section, big tech companies benefit from legal immunity of which shields them from liability for content posted by third parties on their platform. We submit that this legal protection recognizes the impracticability and potential effects of holding platforms responsible for user-generated content. Platforms can be able to help in reaching solutions for the content that is incorrect on their platforms, but they do not have a legal responsibility. Maybe they have a moral obligation, but this is a legal question and a question of liability. And so in the question of liability, according to Section 230, they are not liable. And even if they were to be liable, they should not be the only ones liable. And governments should also be responsible for the surveillance of media sharing in their countries. And so we respectfully submit as well that in Zerand versus America Online Inc. In 1997, the case that established broad scope of immunity provided for by Section 230, Kenneth Zerand sued American Online for failing to remove defamatory posts about him on his platform. In that case, the court held that AOL, American Online, was immune from liability under Section 230 because it was not the publisher of the defamatory content. And that concludes my points.
Thank you for your submission. We'll now hear the second rebuttal in the favor position. Team of Sofia University, you have 2 minutes.
I would like to ask again if I'm audible and visible.
You are.
Thank you. Okay. The opposition argued that regulation only by the big tech will put a burden to the freedom of speech. We disagree, and we believe that giving the responsibility solely to the big tech companies will promote more transparency. Dear judges, it is clear by the national legislations of some countries like China, India, Turkey, Iran, and Russia that countries tend to put censorship over the content and remove information that is not aligned with their political views. If the regulation is done only by the companies, such political censorship will not exist to such extent. Another point I would like to make. A great amount of the argumentation of the opposition was based on the Section 230, but we already mentioned it in the beginning that this act was proclaimed as unconstitutional. But even if we don't take that into account, it is seen by many professionals as inadequate. Also, please note that in recent months there have been a lot of suggestions from both the Democrats and the Republicans in the US, that are the policymakers, to change the law. Dear judges, I would like to move to our last argument. Dear judges, nowadays the dissemination of misinformation on social media platforms represents a significant concern. It is crucial that big tech companies such as Facebook and Twitter assume responsibility for verifying the accuracy of the content that is shared. This measure is essential to protecting users from potential harm brought by misleading information. For instance, the adverse impact of misinformation during the COVID-19 pandemic. False narratives about the virus's transmission, treatment, and preventative measures circulated widely, and this led to confusion and, in some cases, bad decision-making. Furthermore, the frequency of fraudulent schemes and scams on the internet underlines the need for strict content verification procedures. if big tech businesses were required to guarantee the accuracy of the information, users might be protected from this kind of malicious activities. Please note that sometimes even a small piece of misinformation could affect the life of an individual. Thank you.
Thank you for your submission. We'll now hear the second rebuttal in the against position. Prince Sultan University, you have 2 minutes.
Thank you. Am I audible and visible?
You are.
Thank you. I'm sorry. It appears that my camera is off. Is it off for you as well?
We can see you.
Okay. Thank you. Right. So, respectfully, with respect to the opposition's points about how the act was proclaimed as inadequate, we respectfully submit that although the act was general, we may interpret it in it's still the Congress's suggestions up until this point have not been passed, and so we respectfully submit that since the act still stands and since this act still grants immunity to those social media platforms and big tech companies, then that grants them immunity for the current moment, and that's how it should stay. Because censorship would not be better if it were to be from big tech companies or from rather than governments. Censorship is censorship in the end of the day, and governments do hold a high responsibility towards such a thing, and that responsibility can be seen in Article 19.3 of the ICCPR, which is binding on states, where it says that for a limitation to political or free expression to be made, it must be provided for by law, must serve a legitimate aim, and must be necessary and proportionate. So respectfully, can we trust for these social media platforms and big tech companies to follow such a criteria when this criteria has been customarily used against governments rather than social media? And so we respectfully submit that the Reynolds versus American Civil Unions case did not debunk Section 230 of the case. I'm sorry, I could not see, I can't see your camera, so the problem is that I can't see the yellow and the red.
Yeah.
It's paused right now, your timer. You have 30 seconds left.
30 seconds left?
Yes.
Yes.
Thank you very much. Okay. So with respect to that, in the protection of freedom of speech and with respect to censorship, we respectfully submit that big tech companies should not be the only ones responsible for verifying the accuracy of content, and rather it should be governments, and governments should be held accountable in criminal or civil law point of view, as they have been in human rights courts across the world. With respect to the limitation, like in the Kavala versus Turkey case and in the Handicide versus the UK case, where in both cases, content shared or the practice of freedom of expression was limited by those governments, and those governments were held liable with the respected actions. And that concludes our points.
Thank you. Thank you to both teams. We have now heard the rebuttals from both sides. We'll proceed with the conclusions. Starting with the team in favor, Sofia University debate team, you have 2 minutes.
For the last time, I would like to ask if I'm fully audible and visible.
You are.
Thank you. I would like to make a last remark about Section 230. It's a very old act, about 30 years old, and it obviously doesn't address the matter properly, and there's a need for newer regulation, and it's a matter of time that it will be done in the US. I would firstly like to thank the opposing side for their statements. Throughout the course of this debate, we have elaborated on why big tech companies should be the only ones responsible for verifying the accuracy of the content that is placed on their platforms and be held liable from a criminal and civil law point of view. This is evident from the cases of Stratton Oakmont versus Prodigy Services Co. and Reynolds versus American Civil Liberties Union before the US Supreme Court. This is the only way the best interests of the users can be protected. Dear judges, we first addressed how big tech companies will regulate their content better because they have the financial and technical resources to verify it effectively. We refer to regulation on tackling terrorist content online by the EU from June 2022, which gives the responsibility for regulation to this matter to the companies. Secondly, we pointed out that the regulation will be more effective when it comes from one source, the companies themselves. We supported our point with the professional opinion of Danielle Citron and Benjamin White in their article in the 2017 Fordham Law Review Plus, we mentioned the case of InfoWars versus YouTube before the District Court of Texas, and this point still stays in the debate. Lastly, this measure is essential to protecting users from the potential harm brought by misleading information. This is evident from the situation with the COVID-19 pandemic that we recently provided. Misinformation is a significant problem in the online community, and the big tech companies play a major role in addressing this problem. We have illustrated through our arguments that this is the best approach to this matter. Thank you for your kind attention.
Thank you for your submission. We'll now hear the concluding statements in the against position. Prince Sultan University team, you have 2 minutes.
Am I audible?
You are.
Upon reflecting on the points raised, it is evident that the large landscape of modern communication is heavily shaped by the presence of these big tech giants. Indeed, they serve as channels for the exchange of ideas, information, and discourse on a global scale. Yet the question of accountability becomes very important in the digital arena. As we navigate through this terrain, it is essential to recognize the fundamental and foundational principles that lay out the Section 2030 of the Communication Decency Act. This legislation was crafted to foster innovation and protect the free flow of ideas by shielding online platforms from undue liability for user-generated content. The legal precedents cited, such as Zerna versus the America Online case, underscores the importance of maintaining the legal framework. They affirm the platforms like the AOL cannot be held responsible for the actions of their content users online, a principle that has been crucial in enabling a vibrant exchange of ideas online. Moreover, the case of Gonzalez versus Google highlights the ongoing debate surrounding the platform's liability of exchanging and challenging regulations through third-party content. While tragic events such as the Paris attacks understandably promote calls for accountability, it is crucial to tread very carefully to avoid the shifting and crafting of new expressions and free expression. Indeed, obligation of big tech companies to verify content accuracy risks overreach and censorship, undermining the very important principle of freedom of expression that we hold very dear to us. Legal protection proves itself unreliable when it comes to these big tech companies. The matter at hand concerns the tendency of large corporations to promote their own agendas. It is essential to acknowledge that censorship, regardless of its course, remains censorship. Merely because it's emitting for a non-government entity does not render it morally superior or more acceptable. In closing, let us remain vigilant in our pursuit for truth, integrity online, while also safeguarding the principles of innovation and free expression in our digital age. Thank you.
Thank you very much for your submission. We have now heard all the statements, all the positions that are possible during the debate from the two teams. Congratulations. Congratulations on your match. I would also like to thank the 3 judges again that will be reviewing this match in their time. We look forward to sharing the results and the feedbacks shared with you through the forms and also through the results announcement. In the meanwhile, we'll do a little feedback round with all of us that are on the call right now, starting with the Prince Sultan University team member. Perhaps Ms. Hashem, if you could start us with, how did you find the debate? What was the preparation like?
It was really interesting. I do love, and I'm very indulged in big tech. And I always had that same question of, is it fair to hold one entity reliable? If the government is reliable, it might censor free expression, but then if the entity is reliable, it might push its own agenda on things that we don't agree with, and the values and goals of each country is so different. So it's a very interesting topic.
Thank you for sharing. What about you, Ms. Angelova? How did you find the debate and the preparation?
I'm sorry. I also find it very interesting. It was very challenging, but in a good way. There was a lot of information actually and a lot of debates online about this topic. So I think it's a very in the trend right now. It's very interesting. So yes, I really liked it.
Thank you for sharing. What about you, Ms. Sahab? How did you find the debate, the topic? Perhaps is the topic of disinformation present also in other areas of your studies aside from this debate?
I think it was one of those topics that's definitely discussed in the classroom a lot, especially with big tech being such a daily occurrence. We use it every day, and I think it was one of those topics where I really did not mind getting either side. You always kind of have a preference of what side you want to debate. I was, very excited and ready to do whatever. So that was very interesting and really good to have.
Thank you for sharing. How about you, Ms. Mukherjian? How did you find the debate, the topic, and perhaps is this information present in other areas of your studies as well?
First, I want to say it is honor to be here. Topic is very interesting and challenging. From big tech, like Meta became a part of our life, and it's too interesting to get many information for it.
Thank you for sharing. Mr. Hashim Ashram, how did you find the debate, the topic, the preparation?
Yes, this was a bit of a difficult topic to prepare for. It's a very interesting topic. I may be too early in my studies. We have not touched on this subject specifically, but there was a bit of tort here, a bit of liability as well. Interesting philosophies and interesting areas of law that mixed into this topic. So it was a pleasure debating against the other team, and yeah, it's an excellent topic, and it was fun researching for it.
Thank you for sharing. I would also now like to give the floor to the mentors present on the call, perhaps starting with Mr. Kuchikov for the Sofia University team. How did you find the debate? Is there anything you would like to share with the students?
Hello, everyone. So firstly, I would like to congratulate both of the teams. You did great. And I think that the topic was specifically formulated in that way that it made you think a lot and it made you read a lot about the topic. And that way you were able to further improve your debating skills and your overall communication skills. And that way, I think that this is like the debate match is the fruit of great preparation and just overall clash of the different skills that you have. So I'm really glad that that happened today in the quarterfinals.
Well, thank you for sharing. I would also like to give the floor to Professor Mukrabia for the Prince Sultan University team. How did you find the debate? Is there anything you would like to share for the students? Professor, I don't know if you can hear me. All right. Well, perhaps some technical difficulties. If
Yes,
there is,
apologies.
oh,
My internet just lagged.
right,
Yes,
the floor is yours.
but I heard. Yes, I just wanted to say that I'm incredibly proud of both teams. This topic specifically during my studies back in the day, it was incredibly prominent and we've discussed it even back then. So in this day and age, it's much more broad, and I'm very glad that the students of today get the chance to learn more about the topic. So it's an amazing pick, and I'm very proud of both teams. They both performed amazingly today, and good luck to both of them.
Thank you for sharing, Professor. All right. Well, as always, the judges have 2 business days to review. Of course, as soon as we have the results, they will be announced and the details will be shared with you with the forms. For the final part of the session, as we always do, there's a little bit of networking possibility. On the side of organizing team, we always hope the teams stay in contact, be that during their studies or perhaps you reconnect once you become professionals. And on that note, that's the question for today's session, and that would be, what do you anticipate or envision for yourself after conclusion of your current studies? Are you continuing on the academic journey, or are you considering to become a practitioner, perhaps directly dealing with law or on the international level? Perhaps starting with Mr. Ashram, what are your next steps, do you think?
So after my studies, I plan on working in an international law firm, commercial international law firm, and then after that, at some point, I want to go into arbitration, hopefully.
Thank you for sharing. Ms. Angelova, what about you? How's the next step looking?
Well, I'm really early in my studies, so I'm not quite sure, but I really like international law, so maybe I'd love to work something with that. I also like mediation a lot, so if I could work in one of those fields, it would be great.
Nice, thank you for sharing. Maybe that could be some point of reconnect with your opposing counsels later in the future. Ms. Sahab, how do you think are the next steps for you? Are you considering working with law, perhaps?
I definitely want to pursue my education further. I would love to get a master's and a doctorate. I just love learning and hopefully, also be able to try out being a professor for a little bit, teaching other people. It's always been a dream of mine.
Thank you for sharing. Ms. Mukherjee, what about you? Maybe an academic career?
I really want to work some international company, and to learn abroad is one of my first step, I think.
Thank you for sharing. Ms. Hashim, what about you? What do you consider that might be the next step?
I really am interested in consultancy. It's pretty big here in Saudi, and I'd love to delve into that world. You get to dabble in almost any field imaginable, and it's quite interesting. So.
Well, thank you for sharing. I don't know if you, maybe just a general question to the two teams at the same time. You can pick, of course, which one of your members will answer. Did you have a chance to see when you were preparing for this debate the previous matches of your opponents? Perhaps first the question to the PSU team.
Yes, we did. We did watch a lot of them actually to practice.
What
And
about
if I may
Sofia?
add, sorry, please go ahead.
No, go ahead.
If I may add, the other team we watched Sofia University before on YouTube, they did an amazing job in that debate, and then they did as well, and there was like many improvements that we saw in this debate. Honestly, excellent job to the Sofia team in the previous match and in this one.
That's lovely. Sofia team, the floor is yours.
Thank you, Will. I would like to thank the Prince Sultan team for their statement. We also watched, I think, at least 2 of your videos from the previous matches, and from the first time that we watched, we were able to see that you're a great team, and you prepare very well. You talk perfect English, and obviously you're a strong opponent. So yes, but it was enjoyable to watch your matches. They were really interesting.
Right. Well, on the side of organization, there is not much further to add. Really, I just, if I can any more than already did, to encourage you to stay in contact and to continue sharing the experiences that you will have as young professionals in the market, as well as in your different areas that you choose to pursue. Of course, we also hope to see you in The Hague for the final week. It will be happening on the week of 19th of June. There will be possibility to visit different organizations in the city, as we always organize for each edition. And of course, there will be a big reception for everyone, also with the sister competition that will be concluding in the same year, same week. If you are considering to travel in to the Netherlands, there is a possibility that we can share with you some discount codes for airfare. Definitely do not hesitate to reach out to us. We'll also be sending an email communication with the details further. And that would be all. Just once again, congratulations, everyone. And I pass the floor to Professor Lovange to wrap us up.
Yes, it was a very, very nice quarterfinals match. Congratulations to both of you on a topic which is technical and at the same time indeed very much in the news nowadays. And obviously we are using some of these platforms by big tech for this competition, so it is very relevant. And so many thanks again, and we hope that, yes, you will keep contact as well between the two institutions, because there are many possibilities of collaborations, I guess. And for us, yes, next week we'll inform you. And don't forget to watch as well the other match of future opponents, because yes, we had one on Wednesday, one today, and there will be one next week and the week after. So it was spread because of exam periods, etc. But many thanks again. It was a pleasure and an honor as well to have this match today, and we wish you a very good end of the week as well. Thank you.
Thank you, everyone. Goodbye.
Thank you. Bye-bye.
Bye.
Thank you so much. Thank you.
Thank you.